Friends, now come to transfer power of Supreme Court under section 406 of Criminal Procedure Code. That means criminal matters. So, what is the power of the Supreme Court in criminal matters? Transfer power of the Supreme Court. So, Section 406, Section 25, 139A1 of Constitution of India, we know that all these are the provisions giving power to the Supreme Court for transfer of a case. Before going into details, now come to verbatim. What is there in Section 406 of Code of Criminal Procedure Code? So, see, what is 406 saying? What is the title? Power of Supreme Court to transfer cases and appeals. Cases and appeals. What is that? Cases and appeals. Not only cases, appeals also. So, what is the language? Whenever it is made to appear to the Supreme Court. So, the literal meaning is made to appear to the Supreme Court means satisfaction. Just like in Section 25, made to appear to the Supreme Court. So, Supreme Court has to satisfy, made to appear. Who is responsible to made to appear? Normally, who approached the court has to make to appear to the Supreme Court. What has to be made to appear to the Supreme Court? What is that? An order under this section is expedient for the ends of justice. So, Section 25 CPC is having the same language. What is that? Expedient for the ends of justice. What is expedient? In one meaning, it is convenience or what do you call? In the interest of justice. That means convenience. So, advantageous. Convenience or advantageous. So, Supreme Court has to satisfy that an order under this section. So, order has to be passed under this section. Why? Because it is expedient, because it is convenience or advantageous for the ends of justice. So, here ends of the justice is important. If court feels that, then it may direct that any particular case or appeal be transferred from one high court to another high court. So, here transfer high court to high court or a criminal court subordinate to high court. So, criminal court subordinate to high court to another criminal court of equal or superior jurisdiction. Another criminal court, it also should subordinate to high court, but it may be equal or superior jurisdictions. It is subordinate to high court, but either equal to first one or superior to first one, but it should subordinate to High Court. But it should subordinate to High Court of another High Court. So that is the condition. So according to this section, Supreme Court can transfer a case or appeal from a High Court to one High Court to another High Court, or criminal court subordinate to one High Court to another criminal court of equal or superior jurisdiction, but it should subordinate to another High Court. That is 406 clause 1. Then who can move this application? Here 406, regarding 406 criminal matters, it is somewhat different from Civil Procedure Code. Here Attorney General of India. Who is Attorney General? He is the Chief Legal Officer for the central government. Central government. First lawyer of India, in other terms, or the real meaning is Chief Legal Advisor of central government. So he can move this application. Why? Why? Because this is a criminal matter, public interest of justice. That is important. So state is responsible for the criminal justice, implementation of criminal justice, administration of criminal justice. So for that, Attorney General has been given the role. That is one choice. Another is of a party interested. Of a party interested. It is not party to the proceedings. CPC, a party to the proceedings. Somewhere, any party or either party. A party to the proceedings, either party to the proceedings, any party to the proceedings. These three are absent here. These three words are not here. What is there here? Here, a party interested. So this phrase is having wide import. That means wide significance. Here, to justify this phrase, any person can, of course, it is not settled, but it is a wide import. According to this word, any interested person can file the transfer petition. Two chances are given. One is any party interested, another one is Attorney General. Both these persons can move this application. Okay. Application shall be made by motion. That means somebody has to make a mention, make a move to set it, the law into motion. That means filing of application or such. Suppose, except when Attorney General of India or Advocate General of the state, except these persons, suppose application is moved by Attorney General or Advocate General of the state, there is no need filing affidavit or affirmation. In all other cases, the petition should be supported by affidavit or affirmation. We know that normally every petition will be supported by affirmation, would be supported by affirmation or affidavit. That means why that petition is to be allowed. has to be stated in the affidavit. So clause 2 deals with these aspects. So who can make apply, and what is the accompaniment along with the petition. Come to clause 3. What is the fate of dismiss? What is the fate of petition if it case dismissal? Or otherwise, what is the procedure of dismissal? Suppose application under this section has been dismissed. Normally, merits also it can be dismissed. Merits it will be dismissed. While observing that merits, suppose Supreme Court feels that it was a frivolous or vexatious, it can impose compensation or cost up to 1,000, not exceeding 1,000. Suppose it is in CPC, it is 2,000. Here, it is 1,000. So, up to not exceeding 1,000, compensation can be given. To whom this compensation? Other side, who has opposed the application. So, this is section 406 verbatim, exact words of section 406. So, clause 1 deals with the grounds. On which ground 406 application shall be allowed. Who can move? That is clause 2. And the power of the compensation to pay to the respondent is the clause 3. Okay. Come to the grounds. Come to the grounds. The grounds must be, in criminal case, the basic, the very few grounds are there. Normally, one proverb is there in legal that is called, justice should not only be done, but it should seem to be done. What is that proverb? Justice not only to be done. So, justice not only be done, it should seem to be done. That means all the persons who are watching also has to perceive that justice has been done. That is the meaning. So simply we done justice is not enough. It should seem, that means it visible in such a way that justice has been done. That is also necessary. So for this purpose, suppose court feels that there is no chance of fair trial because of subordinate courts action, or any apprehension that the accuser is not getting or is not likely to get a proper, fair and impartial trial. So what is the important point? I already told that fair trial. What is that? Fair, impartial, trial. This is important. The trial should be fair or impartial. So, proper trial. These are the two grounds. One is this proverb, another is trial. In Manek Sanjay Gandhi case, in one of the case, Maneka Gandhi case, Justice Krishnaiyer observed that fair trial, assurance of fair trial is also an important ground to transfer. Next, convenience. Neelam Kanwar. This is 2000 judgment. Neelam Kanwar. In this case, convenience of wife. That means convenience has been given importance. Whose convenience? Either wife or husband. Wife convenience has been given priority, so that basing on that ground, petition has been transferred where wife was residing. So this principle is being followed by Supreme Court and all other high courts in the country in all matrimonial disputes. Of course, exceptions also are there when circumstances requires otherwise. So, it is general principle. We know that for every rule there are exceptions. When advanced stage is there, sometimes in normal, when trial going to be concluded in such a condition, no transfer petitions will be allowed, even on the application made by wife in some cases. But of course, case to case varies the orders. Next, in state of Assam versus one Gogoi case is there. In this case, Supreme Court exercised its power sumoto. It's a power of 406 sumoto. That means in one SLP, Supreme Court transferred the criminal case from one court to another court. That means, what is that? Supreme Court, of course, there is no such a specific order, but because of that case, we can understand that Supreme Court can sumoto transfer criminal case from one high court to another high court, because it is happened in that case. Okay. Next, come to state of Assam versus Brojan Gogai case. So, convenience is the one ground. Next, reasonable apprehension. Reasonable apprehension of bias. Reasonable apprehension of bias. This we have to understand that. What is reasonable apprehension? And also what is convenience? Convenience also having one detailed meaning. Whether it is a convenience of witness, whether it is a convenience of petitioner, normally all things has to be taken into consideration. Simply convenience of the petitioner alone, that too relative convenience. That means suppose petitioner is more convenient if suppose is transferred to another high court or another court, then it is not a important point. It should not be relative inconvenience. In such a cases, normally Supreme Court do not entertain. So witness and other parties, atmosphere or other things has to be taken into consideration for the word convenience for the purpose. Prosecution side, witness, larger interest of the society, all these things has to be considered according to Supreme Court judgment in Abdul Nazar Madri. Next, suppose state is discriminating. You take in a Jayendra Saraswati case 2005, suppose state is acting against a person apparently prosecuting agency or state machinery, so creating a reasonable apprehension in the mind of the petitioner or co-accused, then it may be transferred. It is happened in Jayendra Saraswati case. Suppose state or prosecution agency, if these two are responsible for creating such a reasonable apprehension in the minds of the petitioner, then it can be transferred. So this is reasonable apprehension. So consent will result in a failure of justice. Reasonable apprehension. What is the reasonable apprehension of bias result? That result in failure of justice. So that keeping that point, normally courts will entertain petitions. But in my experience, a reasonable apprehension is a dangerous ground, because if we set out this reasonable apprehension of bias, what is reasonable apprehension of bias? This apprehension of bias is against judiciary, judges. Suppose we want to transfer a petition from one court to another court on the ground that judges is having some bias, or even some relation of the judges are having in that court, we may get such a reasonable apprehension. But unless we have some material to show that reasonable apprehension of bias of judiciary, we can't seek transfer of petition. If we ask that petition on that ground, we may face contempt of the court, unless it is not well established. So this ground has to be taken care. So this is about the grounds and scope. Come to procedure. Regarding this procedure, Supreme Court rules 2013, Order 39. Supreme Court rules 2013, Order 39. Not like this. We have to use Roman letters. Okay, come to these 4 rules are there in this order. What are the 4 rules? The first rule deals with what are the contents of the petition and affidavit. You see, every petition should be in writing and should contain separate paragraphs and particulars of the case concisely. Concisely means in brief, why he is seeking transfer, what are the grounds, what are the minimum brief facts, and all that things should be there in petition. And this petition shall be supported by affidavit or affirmation. Come to rule 2. This is regarding with the hearing procedure. After filing petition, What is the hearing? At the stage of first hearing, that is called preliminary hearing. A preliminary hearing, court will decide. Court has two options. At the admission, at the preliminary hearing itself, court can dismiss the petition or issue notice. What are the grounds available to the court for dismiss the petition? One is no prima facie case. One is no prima facie case. Second one is otherwise untenable. Otherwise untenable means there are any reason which can say that this petition is untenable. Untenable means not maintainable. So, court at the stage of preliminary hearing satisfies that there is no prima facie case or otherwise untenable, dismiss. Or it feels that there is a prima facie case, notice can be issued to the respondent side why this order should not be made. Suppose here accused is not a petitioner, then notice should go to accused. In all other cases, state must be, in all other cases means even if it is accused, state must be one of the party. State must be one of the party. Suppose the accused is not a petitioner, notice should go to accused. So this is the notice consent. Come to how this notice has to be served. When notice should serve to all the parties interested. All the parties interested. That is one condition. Next one is notice shall be served not less than 21 days. So 21 days, prior to 21 days, the notice shall be served. These 21 days what? Before the date fixed for the final hearing of the petition. So, before final hearing of the petition, notice shall be served. Then, opposition, affidavit in opposition shall be filed in the registry not lesser than 4 days. That means 21 days time is there. Before 21 days, it should reach the respondent. So, after receiving this 4 days before that final day, 4 days before that final hearing of the petition, affidavit of opposition, that means counter, affidavit of opposition, who can file? Respondent. This affidavit of opposition can be filed by respondent 4 days before the final hearing. Then 2 days before the final hearing, reply can be filed by the petitioner. Reply. So 4 days for affidavit in opposition, 2 days for reply. The date after hearing, and the affidavit in reply shall be filed not later than 2 p.m. preceding the day of the hearing of the petition. Sorry, it is not 2 days. Here, reply can be filed not later than 2 p.m. preceding the day of the hearing of the petition. Suppose hearing is happening on 1st 1/1/23. So you can file 31/12 2 p.m. up to 31/12 2 p.m. you can file 31/12 of 22. So 1 day before up to 2 p.m. you can file reply. So this is the, in other cases 4 days, when 4 days given affidavit of opposition, 2 days will given to reply. But here for up to 1 day, 2 p.m. of the preceding day has been given. So these copies of affidavit in opposition, that means counter has to be served, a reply also served on the opposite party and the parties, and affidavit shall not be accepted in the registry endorsement of service signed by such parties. So we know that this is simple rules regarding service of affidavits. So one person has to serve other side, and other side has to serve. He has to serve counter other side. He has to serve reply this side. Unless endorsement to that extent is there, normally registry will not accept. Suppose if dismissed the court on the ground that it is frivolous or vexatious, so compensation can be given by the court. According to this rule, there is no 1000 limitation. For other side, court can order compensation. How much it may consider proper in the circumstances of the case. So this is regarding 406, section 406, Criminal Procedure Code, power of Supreme Court, when, how it will exercise. The next video will be done